Welcome to the third public evidence session of the Communications Data Bill. Welcome to our panel of witnesses. Again, we're under a tight time constraint. We have a lot of witnesses to hear from today, a lot of evidence we wish to gather, and a lot of questions we wish to ask. So perhaps we could crack on by asking each member of the panel to briefly identify themselves, and then we'll start with the questions. Yes, Mr. Davies.
Good morning. My name is Peter Davies. I'm the Chief Executive of the Child Exploitation and Online Protection Centre.
Thank you.
Trevor, Pearce, Director General, Serious Organised Crime Agency.
Yes.
Toon, Director of Criminal Investigation, HM Revenue and Customs.
Thank you.
Cressida, Assistant Commissioner in the Metropolitan Police.
Beautridge, Assistant Chief Constable, Head of the Kent and Essex Serious Crime Directorate, and I chair the Data Communications Group for ACPO.
Excellent. Thank you very much. Could I suggest to the panel, we've a lot of questions you might all want to answer, but if every one of you answers every single question, we'll be here till midnight tonight. So please feel free that all of you don't have to answer each question and select amongst yourselves who's going to take the lead. But don't be constrained. If you have something to say, say it. Could we begin then, Dr. Havert?
Thank you, Lord Chairman, and thank you all for coming. Can I start off by understanding how things operate under the existing laws? Could you perhaps each briefly say how much communications data do you currently use? How many requests did you make in the last year? How many people did that apply for? What were the purposes and how many cases were successfully prosecuted or concluded?
I can't give you all that data. I'm happy to supply it in writing later on. As a general overview, we seek roughly 3,500. We make roughly 3,500 applications per year. A proportion of those are unsuccessful. We are slightly unlike some of the other colleagues represented here in that we don't then go and make arrests, for example. We pass high-quality intelligence on to others, including the law enforcement community and children's services, so that they can do safeguarding interventions or arrests. But that's a picture of the kind of volume. And of course, again, something that slightly distinguishes us is the vast majority of those are comms data in relation to online activity. So we have a slightly different picture, but that's all.
Clearly, sir, our remit is around serious organised crime, and that is what the focus is on. About 95% of our investigations will have some kind of communications data attached to it. An example, I think in April and May, of the 13 cases which were prosecuted by the Crown Prosecution Service on our behalf, 12 of those had fundamentally communications data as the centre of it. In relation to the sort of specific numbers, we're happy to follow up with in communication.
From our perspective, 2011 we had 5,000 applications, 15,270 individual items of data. The impact of that, the easy way to give an indication of the impact is that is directly related to about £850 million of protected revenue through a significant number of cases.
In 1 year? In 1 year, perhaps.
So the Metropolitan Police, we obviously have a responsibility for a large proportion of serious crime, organised crime, and also, of course, counter-terrorism and other forms of crime. So we use this in terms of preventing and detecting crime. We also use it hugely in terms of saving people's lives where there is an imminent threat to their life. We also use it because we are, if I take terrorism as the example, we are the agency that, with the Crown Prosecution Service, bring evidence to court. So we present this data in evidential form as well. We are, I can't give you the exact figures, but we are, of course, by far the biggest police service, and we have much the biggest use.
But you'd be able to send us the figures on the people, cases, requests?
I certainly will attempt to send you the figures you're looking for, yes.
Good morning. In my own two force areas, last year there were 10,107 applications, of which at the point of first contact 2,577 were declined as not meeting the standard by our single point of contact.
Sorry, how many was that?
2,577.
Were declined?
25.49%. And a further 112 were then later declined by the dedicated person who reviewed these incidents. We've just recently conducted a 2-week survey nationally in respect of the number of applications, and I can certainly provide that in written format to the committee should that be required.
Thank you all very much, and I look forward to seeing more of that data. You clearly make considerable use of the communications data at the moment, though I'm slightly concerned about the 25% that are declined. What's not clear is what data can you currently not get? I mean, the Home Secretary's spoken, for example, about Facebook and Google. As I understand it, Facebook and Google do comply with a number of requests. What is it that you can't get from them at the moment?
So, if I could start, I'm not technically qualified to tell you that at all. What I can say is that when I sit down with my senior investigating officers, both in counter-terrorism and in serious crime, they say that they all have experience of not being able to get the data that they would like, and that they are feeling that increasingly. But you don't know what sort of data it is. You know, if Google said we'll provide you with anything you ask for, you couldn't tell them what you want. No, I am never myself an applicant. Of course, when we apply, we are always very specific as to what we are looking for, and there is an increasing amount, which it is very either impossible or very difficult to get. And could you tell us what it is that is missing? Because I think we're trying to understand what the gap is that needs to be closed, so we can work out how to close it. Well, I think it would be difficult for reasons that you would understand to be hugely specific in terms of you know, the precise type of data, or indeed the companies in some cases, because that is obviously something that we actually sitting here don't want to tell all the criminals right now.
Is it because the information is not available, or because it's withheld? You have any figures
by the service providers, you mean? My understanding is that it's more often that it is not available, and increasingly so. Occasionally, of course, it is also withheld.
Mr. Hubbard, carry on.
Well, I think Mr. Beautridge and Mr. Davies both wanted to comment. So.
Yes, sir. In some regards, we don't know what we don't know. However, there is a lot of information that is being requested through our own single points of contact that we know is not available. To open that up publicly would expose some vulnerabilities for the service. I would very much like to take the opportunity to write in on that specific point, which would illustrate the type of information that we do not have access to.
I think that would be very helpful.
I'd like to echo that, and I think there are 2 points. One is there are certain types of data that are not currently available through any legislation, which are gaps that we don't want to expose to the public for reasons that Commander Dick has highlighted. The other is that there are some providers who are better, quicker, more comprehensive at providing the data on request than others. And so some of this is occasionally about which provider you're going to ask, and that how you have a different level of confidence in the likelihood of a reply.
Now, presumably none of you have seen the draft order that would go with Clause 1 of this bill. So do you have any way of knowing whether the data that you're currently lacking would be acquired even under this legislation?
I suspect, I speak to my colleagues to say, we are, I'll speak for myself, I believe that this is absolutely fundamental. I would like to maintain the capability we currently have. I'm absolutely not technically qualified to describe how we would do that. Okay. So I can't.
So we can't get the technical details. If there are people in your organisations who have the technical information that would be helpful to this committee, I think we'd appreciate it.
Maybe use this committee as we've done with other committees, which is certainly in relation to soccer because of its wider responsibilities around more broader technical issues, to offer the committee the opportunity to come and take a briefing and to watch this in action. So we would put some more of that context around the answers which we're not able to give here.
We'd all very much like that.
Yes. I think that might well be helpful. One last question, if I may. A number of the communication service providers who are overseas, who I understand from what Home Office and Home Secretary have said are part of the issue, are based in the US. There are a number of other countries. There are mutual legal assistance treaties between us and the US, so presumably it would be possible to get data from them direct from source using the MLAT approach. Have any of you used that or have any experience of doing that? You must in soccer.
I mean, it can be used through the letters of request, but I mean, it's about the nature of what you can ask for. So in some regards, perhaps a specific piece of information can be obtained. More broadly, in terms of how do you carry an investigation where you're seeking a range of conspiratorial material, that is more of a challenge.
I agree with that. I think there are also issues where we go abroad in terms of the duration of data retention, particularly in the online world. There may be some delay between the piece of data that's being sought and the request being submitted, there are MLATs, there are international letters of request that can be made, but there is a delay involved, and that's where the time limit comes in. And so some of the attrition in getting data back is due to the expiry of some of the time limits.
How long a delay, and does that just argue that the MLAT process could be made faster?
I don't think it's necessarily all about that. I can't give you an exact figure on the delay. What I can tell you is that if, say, we worked on a principle of retention of 12 months, there are some aspects of our investigations for which 12 months still isn't long enough. And of course there is a delay in doing the international request process.
Mr. Beautridge wanted to add a point.
Just on that point, certainly there is an inconsistency of approach amongst different CSPs that are not located within this country. We do approach them for information and evidence. Some supply it in the format that would be required, others do not. There is not a consistent approach at the moment to the provision of this information from overseas providers, and I could provide specific examples of that should that be required as well.
Yeah. Mr. Whittaker, you wanted to come in this? Then
yeah, could I just ask what proportion of your overseas requests you don't get any information at all? So is that a big problem for your organisations?
I'm sorry, sir. I would have to say I would have to go and research that,
okay.
And we would intend, with the chairman's position, to give a written submission later. We can put that in that.
Okay.
I think that requires next as well.
Okay, Mr. Mosley.
We had quite a disruptive session yesterday with the sceptics, but what a couple of them did say was that we're all carrying around a tracking device in our pocket, one of these, and one of their concerns was the availability of, sort of passive information between the mobile phone and the mobile base station. Would you want that sort of communications data within this bill?
Well, forgive me, it's been the case for some time that it is possible to roughly, or more precisely, locate a mobile telephone through using communications data. A team that I've led has used that as the almost sole means of detecting a serious double murder in one of my previous forces. So I don't think that's a novelty. Forgive me for, I don't quite understand the distinction between a smartphone, which you're referring to, and what's already been available for many years and has helped protect the public and prosecute offenders in the past with less developed technology in mobile phones.
Okay,
so essentially that communication would be classed as communications data as far as the law enforcement agencies are concerned.
In terms of the identification of a location, then certainly that would be classed as communications data.
Okay. Lord Strasbourg?
Just a bit of clarification on that. Just presumably that's two-way, and that gives the Americans the opportunity to make inquiries on whatever data we're retaining. Is that the case?
The legal assistance process does allow the third-party states to make requests if those requests are able to be made within the UK.
So if as a consequence of this legislation we expand the amount of data we're retaining, that the Americans would potentially have access to that through MLAT.
With the right considerations in place.
Yeah.
I think anybody with whom we have a mutual assistance treaty would technically have access, but of course that would go through some kind of decision-making process in the UK.
Yes. Thank you.
You were able to give us detailed figures for Kent, I think it was, your own force area. Would it be your understanding that every police force in the country would have exactly the same sort of data in the same detail?
Yes, Chair. They should have that type of information.
Excellent.
And it should be capable of aggregation and submission to this committee.
Do you submit it routinely to the Home Office?
Yes, it's submitted routinely to the Information Commissioner.
But to the Home Office, yes.
In the annual inspection.
Right. So the Home Office should already have the aggregated figures for all the police forces in England and Wales?
I believe that should be the case, Chair.
That's very helpful, thank you. Mr. Ellis.
Thank you, Lord Chairman. Well, the government has emphasised the importance of communications data, particularly as regards law enforcement, security, the intelligence agencies and the like, in apprehending criminals and in protecting the public. So could you each briefly say something about how important you perceive this data acquisition to be in your individual experiences? For example, Mr. Toon, I think you said a few moments ago that as far as the revenue is concerned, the revenue was able to secure, was it £850 million last year?
Yes, that's correct. And that's the data that we obtain through comms data authorisations goes into a range of different subjects. 80% of what we obtain is Section C data. Essentially, it's a straightforward subscriber check. What it enables us to do is to identify individuals who are involved in a fraud, which enables us to then further the investigation. If you want some specific examples, we had an operation which led to the conviction of Mr. Kevin Burridge for excise diversion fraud, alcohol diversion fraud.
How much was that worth?
£50 million a year, that particular fraud. He was sentenced to 10 years in prison as the major perpetrator. He had been operating for a number of years, seeking to undermine the alcohol control system, alcohol duty control system.
So it's worth nearly £1 billion a year.
It's worth nearly £1 billion a year. Can I make an interesting point? I think along with that, it's that 850 million refers to the direct revenue loss prevented as a result of the investigations that we carry out. Yeah. In addition to that, what we do is use the results of the investigation often to change our internal processes and procedures, or on occasion to advise Treasury and ministers about potential changes to the law. And that protects a significantly greater proportion of revenue.
Right. Mr. Davies, could you say something about how it's assisted child protection?
Certainly. You asked for personal experience. May I just offer one prior to the child protection example? And it's the double murder inquiry that I mentioned. This was a retired couple shot dead in their home on the coast of Lincolnshire in August 2004 by, as it turned out, one of the preeminent organised crime group currently then operating in Nottinghamshire. Bluntly, without communications data as regards contacts between mobile phones, it would not have been possible to detect that crime and lock up the people responsible. And for all I know, they might still have been operating in Nottinghamshire now had that not been possible.
So that's one double murder.
That's a double murder, but I think that illustrates how long this goes back in terms of being an issue. And of course, bluntly, there were other people involved in the conspiracy who it might have been possible to prosecute and convict, who it was not possible to prosecute and convict because there was a data loss in that investigation. A more recent example, if I may, the force I was responsible for in operational terms commenced an inquiry into a small group of people operating a news group, facilitating the circulation of child abuse imagery on a worldwide basis with over 2,000 members worldwide. The force I was involved in led the investigation. In the course of that investigation, 132 children in the UK were safeguarded and protected. Nearly 200 suspects were arrested and a large number brought to justice. And the 4 people at the heart of this news group operation, which was run for profit and for enthusiasm, regrettably, were convicted. And again, without access to communications data, those outcomes would not have been possible. And may I say, with access to fully retained, fully accessible communications data, more people might have been brought to justice, more children might have been safeguarded.
So I just want to make it clear. You're saying 132 children were safeguarded?
Yes.
As a result of your access to communications data. But you feel that some, because of current gaps in your powers, have not been safeguarded.
Absolutely.
And some child sex offences, some paedophiles are getting away with it.
Yes, and that is still the case today from my current perspective in CEOP. The third example, if I may, just briefly. I know briefly. One of the things we do on a daily basis is help Childline in identifying children who contact them over the internet rather than by telephone. I've got to say, frankly, it is inconceivable to me that we can envisage a society where it is that law enforcement or people like Childline are denied the opportunity to identify children at risk of suicide, locate them, and then get the right thing done about them. And that's a more or less daily occurrence in CEOP at the moment. So we experience data loss there and some of the serious offenders we're dealing with. There are more examples, but I need to be brief.
Mr. Pearce.
So I think if I perhaps focus on 2 areas. Firstly, in, I think, 240 cases last year, we were able to prevent, in relation to either threats to life or kidnaps, attacks which would have taken place on individuals and members of the public. If those had gone through, we know the cost of an average investigation into murder is about 1.8 million. So, notwithstanding the absolute issue of family and the personal injury, there's a fiscal cost to this as well. Secondly, 95% of our investigations will have some kind of communications data in place. Communications is one of the key enablers for organised crime criminals to operate. The range of communication capabilities they now have enables them to operate more conveniently for their purpose, and therefore that has to be available to us if we're going to show the true extent of conspiracies. The significant number of our investigations go into the criminal justice system, and the process of how that communications data was acquired can be tested in the court procedures, as well as the evidential interpretation of the material which is gained.
All right, as far as this point is concerned, though, you say 240 serious and organised criminals, people involved in kidnapping and other very serious offences, in the last 12 months.
No, that's 240 potential threats to life which were averted through access to communications data. Whether that's kidnapping or whether that's actually a significant contract kill.
And you put a cost of approaching £2 million
Yes.
on each investigation if you hadn't had the data.
That would be right, yes.
So that's approximately £500 million
Yes.
saved by having had the data. Have you been restricted or obstructed because you are not able to access communications data at the moment in other investigations?
As in previous answers, there are opportunities which are lost or not available, and we're obviously happy to go into those in more detail.
Yes. And Assistant Commissioner Dick, how do you feel about it from the Metropolitan Police perspective?
At the risk of echoing some of what my colleagues have said, from the Metropolitan Police point of view, if I just took, as I did the other day, a completely random week, we would expect to have probably one kidnap, a sort of operation in which we are putting an enormous amount of resource into, where communications data will be absolutely fundamental. We'll have something like 5 suicidal people who we will find through communications data. We probably have an abduction, perhaps an honour-related abduction, something like that, and we'll have other threats to life. In terms of our murders, speaking to my senior investigating officers, it is extraordinarily rare now to have a murder in London where communications data is not a fundamental part of the investigation. Indeed, if we look at Trident murders, the gun crime murders that colleagues will probably be familiar with, every single one of those, communications data is fundamental to the investigation. You have very few witnesses, you have limited forensics usually, and you are very limited in what you can do, but often there is a call from the offender to the suspect or through another person before the time. It's usually a group of people, they get together, they communicate before and after. It's a vital part of our investigations there. And then if I come to robberies and rapes, very usual for phones to be stolen, often then very quickly, stranger rapes, the stranger rapist will take on many occasions the phone from the victim. Within 24 hours we find the rapist. And if I turn, of course, to counter-terrorism, as you are aware, every single major security service and police counter-terrorism operation involves communications data, and some that are very obviously in the public domain. If you look at the 7/7 investigation, communications data, very obviously extremely important. If you look at Seagram, which was the Glasgow attacks, that we tracked them to Glasgow, we found the bomb factory, and really all of them, we use communications data all the time. And the important thing, of course, is the police use evidential communications data in these investigations.
Now, this bill seeks to redress a mischief, which is that both the Home Secretary and the Justice Secretary have indicated that there has been a degradation, which has been approximated at 25%. That is to say, of the data that can be obtained by police and security services. So we're down to 75% of data. Now, can you say, any of you, are you able to share with us any instance where this inability has impacted, those of you that haven't already said so, on the conduct of your investigation or the prosecution of a case? So are there examples that you can give of people who have not been prosecuted despite the fact your investigating officers knew that, or believed that they were involved in a ring or some other organised crime, but couldn't prosecute them because the evidence couldn't be obtained?
Certainly I could point to cases where there have been prosecutions in spite of not having access to that data earlier, and we've only found out significantly after the events have occurred the activities of the individual in question. One most recent case under my command was the rape of an 8-year-old boy and a 10-year-old girl, where we could not get the information that we wanted, and we had to employ other techniques which were ethically and technically extremely complex, very expensive and very lengthy to bring this offender to justice because of the method of communication this offender was using, which was web-based communications. We similarly have other cases, most recently where 3 people were convicted of a triple murder, where the speed of the investigation was very much directed as a result of access to more conventional communications data, where we could get on top of the case immediately and save hundreds, if not thousands, of man-hours, where we've tracked the offenders from Coventry to Chatham in Kent, where they set fire to a house and murdered 3 people. And that is the opposite side of the spectrum, to show how digital footprints really are key now. They're not a nice to have, they're intrinsic to investigation and intrinsic, I believe, to the core function of policing, which is guardianship, looking after vulnerable people, and that allows us to do that.
Right, so what are the categories of additional data that you would wish to be collected that providers either don't currently hold or that you're not currently allowed to have access to under the legislation that's currently in situ, and that you believe would be necessary for investigatory purposes?
As I said earlier, Sir and Lord Chair, I think that would expose publicly some vulnerabilities that law enforcement have. And with your good grace, we would prefer to be able to submit written evidence in that regard.
Well, I don't press you on that, speaking for myself. As far as, however, this bill is concerned, you're familiar with the terms of the clauses in the bill. You believe, do you, that this bill would redress some of the gaps that are currently in policing as far as these issues are concerned?
Absolutely, I do, yes.
Thank you, Lord Chairman.
Thank you very much. Mr Mosley, at your point? No, sorry, I thought... No. Could I ask, but isn't there a danger? Some of the critics of the bill have said that often you're looking for a needle in a haystack, and if we now give you an extra few billion bits of evidence, we've just made the haystack bigger. What's your response to that? Oh, and Beautridge?
I wouldn't agree with that position. I think whatever we do, there is a proper intelligence and evidential base for making the application. The applications are made on the basis of necessity and proportionality. And indeed, what should not be forgotten is there is a very real financial cost in actually getting this information, and then a further cost if it needs to be evidentially presented. So these matters are very, very carefully considered indeed. The applications are made on the basis, as I said earlier, of intelligence and evidence and in furtherance of criminal investigations.
Okay. Anyone else? Other comments?
I think the issue is partly in the assumptions that lie in the question. And I think one of the key assumptions is that it's possible to make entirely speculative comms data requests and get them authorised. My experience is that that's simply not the case. More typically, one is confronted with a situation where one wants, often after the fact, to reconstruct a criminal network from
you've got a suspect
one or
in
two
mind,
people, and organised crime works through networks, and one has to reconstruct the whole network. The risk is if you settle for one part of the network and you only lock that person up, then the rest of the network is free to carry on offending. So I think the concept that this is purely speculative is against all my experience and against the procedures that currently apply.
Okay, thank you very much, Mr Davies.
Very briefly, Chair, I really would, if it is possible, urge that you come to see one of our units, you look at the application forms, you talk to our staff. It's extremely precise. It's incredibly well supervised and scrutinised. It is not looking for a needle in a haystack on any occasion.
No, the committee will consider seeing how either at SOCA or somewhere the data is inputted, so we will want to probably want to study that in situ somewhere. Lord Strasburg.
Can we turn to the authorisation system for the current arrangements for RIPA? The draft bill has been criticised for not requiring public authorities other than local authorities to seek any independent authorisation to obtain communications data. Instead, a senior designated officer in the same organisation must authorise any request. How does this system presently operate in your organisations?
Which is the applicant to the SPOC who will advise before going on to the designated person who can give the authorisation, and then off to the CSPs. I think the notion is that there has to, as well as to make the judgments about the legality and the process around proportionality, necessity, etc., that you do need also to have some degree of operational understanding, not in relation to that operational activity taking place where there must be some degree of separation, quite rightly, but the practicality of that as it fits in as well to an investigation or to an inquiry. Certainly from my organisation's perspective, the nature of the investigation.
From my perspective, it depends. There are two levels of authorisation in relation to Section C data, the subscriber check data, the lower category of data. We have 100 officers who are specifically trained to act as designated persons in relation to that data. The application goes from a case officer through a more senior verifying officer before it then goes to the designated person for a decision and then on to the CSP. At the higher level data, I have 3 people in one specialist unit who are the designated persons for all applications for the 20% of our requests which are for higher level, more sensitive data.
Very similar for us. We have the 2 levels, the inspectors and the superintendents as the designated persons. The vast majority of our requests are in relation to subscriber checks. The officer goes through a supervisor. They seek advice from the single point of contact, which is a very highly trained person. They then put in their application. It goes to the designated person and comes back through the single point of contact. The designated person in the Met is just about never even in the same unit as the person who's making the application. And of course, the people who are operating as the single point of contact are in a specific unit. They work together all the time, and they are also completely independent of the applicant.
And from my own perspective, so there's very high levels of professionalism around this. Similar to Assistant Commissioner Dick's summary, last year, 10,107 applications in Kent and Essex. These are primarily made by either detective constables or detective sergeants who are officers in the case. The applications go to a separate unit which is entirely divided from those officers and is assessed at the single point of contact. At that single point of contact, 2,577 were rejected. When they subsequently went through to the designated person, who is a superintendent, a very senior officer, a further 112 were rejected. Everything's looked at on the basis of necessity and proportionality. And if it's for the investigation of crime and the protection of vulnerable witnesses or vulnerable people, we need to make sure that all of the human rights considerations are properly considered and that there's a justification process that sits behind it. We would not want well-meaning individuals wading through a thicket of confusion around these issues. These are highly trained specialists who do this all the time and make proper decisions around the applications.
More general point in answer to your question. I think I speak for all my colleagues here and not here in saying that we absolutely understand and respect the need to balance the occasional need for intrusion with a proper, transparent, accountable process to make sure the innocent are properly protected. And in two of the conversations I've had on this issue previously, I have sensed that people have assumed that people would be better protected if there was some alternative means of providing authorisation. Can I just invite you to take a very objective view about the realistic possibility of those alternatives, the cost of those alternatives, and actually whether those alternatives are more likely to protect the innocent than the safeguards that my colleagues have described. And one way, I'll just echo, it is really important, if it's at all possible for you, to go and see this process in action, because I do think it brings it to life.
Can you tell us how many convictions or disciplinary proceedings there have been for misuse of this system?
In my organisation?
Well, yes. None?
None in my organisation.
No, we've had none in our organisation. We have, interestingly, we have regular issues around other forms of sensitive data. Taxpayer, for example, taxpayer data, where we dismiss staff regularly for breaches there. But I think this reflects, I think the zero figure for us reflects the fact that this is a very, very closely controlled area with authorisation requirements before there is any access to the data itself.
If we want the public to have confidence in the police in terms of the use of data like this, we have to take its guardianship very seriously, which is what we do. In respect of data breaches, the sanctions are extremely severe in Kent and Essex. We have one recent case that I can't talk about in detail because it's still going through the judicial process, where something linked to this type of issue has resulted in a criminal charge for a member of my organisation that's currently going through the process.
So, yes, I was going to ask, AC Beautridge, may I ask, are you saying to the committee, so I understand this correctly, that the civil liberties of the individuals and their privacy is better protected by a trained superintendent in a police force than by these well-meaning individuals who may be magistrates?
No, that is absolutely not what I said.
Right.
What I said is we do not want within the police service well-meaning amateurs dealing with these applications, which is why we train officers to a very high level and designated persons to a very high level. Mm-hmm. Nationally, over 10,000 people have been trained in the use of communications data during the last 2 years. Now, absolutely, that was not what I meant. Mm-hmm. I meant that we do not want an artisan approach within the service to dealing with this very, very complex area of business.
Good. I'm glad of clarification on that. I thought it was a general description of the magistracy. One other point, and I'll be very careful here. I don't want to ask about the criminal case. But in principle, then, would you be averse to having a criminal penalty on this bill for people who break, officers in any organisation who break the rules?
I cannot answer on behalf of ACPO in totality because I've not discussed it with my colleagues. A personal view, I think I would not be against that. No, I think this is a very serious issue.
And we've seen in other parts of the Regulation of Investigating Powers Act, notably Part 1. So attaching criminality to communicating certain procedures or processes in place is already there in the current legislation, and I think we recognise it as absolutely vital in protecting those equities.
Mm-hmm. Commissioner?
I can speak for the Commissioner and say we take any breach of any data incredibly seriously, and as you will be aware, we have had examples not specifically around communications data, but more generally of data protection breaches and others, where we will pursue that as far as we possibly can, and regularly, sadly, people end up in court for misconduct in public office, occasionally for computer misuse and data protection. Those are very powerful bits of legislation, in my view. If there was to be another aspect to this bill, how on earth could we object to that? But we do already take this very seriously and have lots of
I appreciate there's a range of other criminal sanctions in other legislation which could catch people here. I was merely asking, I know Parliament is always in danger of adding a similar criminal penalty into every bit of legislation when there's already but do you think it would reassure the public if there was a specific criminal charge in this bill? Okay, thank you very much. Sorry, Mr. Davies.
I'm sorry, I wanted to come in because I probably have the dubious distinction of having some personal experience of the consequences of these things not being done properly. Not, I have to say, on my own part. But in a force I worked in previously, there were processes put in place that were below the standard expected by the Regulation of Investigatory Powers Act. And the consequences were, firstly, that 3 expensive serious crime inquiries failed at the prosecution stage, and the consequences for the officers involved, whether or not they were closely responsible for these problems or whether they were just associated with the inquiry, were very significant in terms of lengthy external misconduct inquiries and for those responsible, sanctions. So I just wanted to mention that one of the other drivers for quality in this is the knowledge that a prosecution might fail because of a lack of the proper process being applied.
Mr. Ellis, you wanted to come back?
Just briefly, thank you, Lord Chairman. You were each speaking of your own public authorities and how infrequent prosecutions or disciplinary action are tended to be for offences of this sort. But have you, for example, Assistant Commissioner Dick, far more experience of dealing with misconduct in a public office for misuse, for example, of the police national computer?
Indeed, I regret to say we do. Data misuse is a considerable risk for all police forces, given the amount of personal data we have. Other systems are more vulnerable and easier to get access to than communications data.
Under the current legislation?
Yes, under the current legislation.
So the absence of prosecutions for communications data breaches, when juxtaposed with prosecutions for misuse, for example, of the police national computer, is a reflection, you would say, of the current security within the system as far as communications data is concerned? Absolutely.
There's a very strong security regime around communications data.
Much stronger than on, for example, the police national computer?
By the nature of the police national computer, every single officer, with some safeguards, and some police staff can have access to the police national computer. The databases on which we keep this information are not the same at all.
Thank you.
Okay. Lord Foulkes?
The access to the police national computer, I suppose, gives you an idea of how these things can be misused. And I appreciate what you've all said about the safeguards that are in existence. What I wonder if you could help us with is, do you think such risk that it is, which you're protecting against, is of collateral use of the material or simply over-enthusiastic investigation?
Forgive me, my lord. When I was answering the last question, I was talking about deliberate leaking, potentially for money, of information. The dangers of collateral intrusion are in the minds of all designated officers and everybody who works with RIPA in all its aspects all the time, and we have to constantly look at the risk of collateral intrusion and how we will reduce that and mitigate that. And if there is a significant risk of collateral intrusion, which we regard as disproportionate and inappropriate, we won't authorise anything.
We know that there were 552,000 applications for data in the last year for which we have figures. I know that you collectively don't account for all of those, but you probably account for a good number of those. And I think collectively you've revealed to us one case of malpractice in terms of applying for this data, if I'm correct. So there's probably only two possible explanations for that. The first one is that your systems are incredibly watertight, and the other one is that you're not aware and not detecting misuse when it's happening. Would you accept that?
I refer to one case within Kent and Essex. We could research if there have been other cases across the country. So I think to make the presumption on the effect of the one case in Kent and Essex and apply it to the national figures would be a dangerous thing to do. That would require more research, my lord.
Okay. Mr. Whittaker.
Yes, thank you, Lord Chair. Can I just ask a quick question on the 552,000 applications? What proportion of those would you say are used in serious crime compared to, I mean, we heard yesterday, I think it was, the applications being also used to chase up speeding fines, for example?
I can answer some questions from the recent survey that we've done. We've done a national survey over a 2-week period. And the results of that survey indicate that 72% of the data requests related to suspect inquiries, 18% related to victims of crime, 2% related to witnesses, and 8% of the communication data requests related to other issues such as missing persons and vulnerable individuals. Certainly the results from that 2-week survey could be made available to the committee, Lord Chair, should you require it. What I would like to point out is that part of my own day job's remit is to tackle serious organised and economic crime within Kent and Essex. And I think the recent national mapping of organised crime groups indicated that there are over 8,000 nationally and over 30,000 members of those crime groups. What I would say from my own experience, which goes over many years, is that an armed robber does not just commit armed robbery. People who are in this for financial gain very much take a blended approach to their criminality for financial gain. So somebody who commits armed robbery, in my experience, if there is a burglary that could be committed, which would release sufficient funds to them, would commit that as well. So when we are tackling organised crime groups, we will take them out in whatever way we can take them out, as long as it's lawful and ethical. And it isn't just for the more substantive, serious crime offence, if we can take them out via other means, and that is what we do. And the use of communications data is intrinsic and absolutely vital to those investigations.
So, I understand that, but my question was specifically what proportion of the information requests are for those serious crimes compared to non-serious crimes?
We could certainly look to disaggregate that out of the recent survey that's been conducted over a 2-week period nationally and supply that to the committee.
Thank you. Yes. Would you like to add?
For the Metropolitan Police, I can say that a large proportion is for serious crime, and there are obviously different definitions of serious crime, but however you define that, for what anybody would regard as serious crimes. And I think you may have heard the Commissioner quote the figure of 23%, or a quarter roughly, of our requests over the last 5 years being for murder. And of course, within our murder investigations and our most serious crime investigations, and I'm sure my colleagues to my right would say this as well, we tend often to make multiple requests. In counter-terrorism, we will make multiple requests for one particular case. So the less serious, the smaller volume of request in the case.
Okay, thank you. Just to move on then, could I ask all of you what the impact will be on your organisations of a system which required to seek prior judiciary authorisation of all requests to access data?
I think we would need to leave in place our internal processes, because that gives us the quality assurance and the operational oversight which we require. There will, of course, be both security, cost, bureaucracy considerations. I think the more significant consideration would be, particularly around some of our responsibilities in relation to threats to life, etc., is the ability to get this speedily on a 24/7 basis.
Okay, all right.
Well, I would certainly agree with that. We would have to retain the processes that we have internally. I think the impact potentially would simply be most crucially felt in those areas of investigation, particularly large-scale organised frauds, where the fraud moves very speedily.
Okay.
And we see a series of organisations that we deal with who will, for example, will change the communication devices they use on almost a daily basis.
Okay, that being the case then, where speed is of the essence, do you think it's possible to devise a system which could distinguish between urgent and non-urgent cases, bearing in mind that, a warrant system, if that was introduced?
I think you can design the system. The current system around directed and other forms of surveillance allows for urgency criteria.
Yeah.
So, of course, the answer is yes, and of course, for all the right reasons, we would want to work within those. But I think we would need to be reassured that the ability to act in urgent situations and the ability to minimise bureaucracy at a time when we're clearly being asked to make significant efficiencies is important.
Okay. Can I ask you then, if a system of prior authorisation was introduced, can you think of any particular permitted purpose for which authorisation shouldn't apply?
I'm not sure that's a question for us in a way, so with respect, I am quite comfortable in policing that it is likely that anybody, having listened to the evidence, would think that the reasons that we use it now are the ones that should probably be retained in the future.
Okay. Anybody have a different view? No? Okay. Can I just ask you then, what would your view on the creation of some form of halfway house system with a level of third-party control falling short of a full warrant system, either in terms of the process to be followed, the cases in which such control was required? And do you have any suggestions as to how such a system might work?
The issues of security and safety of transmission, because this after all is data, so we would need to be reassured, wouldn't we, that whatever the third party did and how they managed the process provided the same degree of scrutiny, information assurance as you are seeking for us in terms of our current acquisition and future acquisition and usage. So security is a key issue to that, whether that's physical, technical, or whether it's personal security. So that would need to be done, and I think it's the availability and the access which is the issue which we would again want to be reassured about.
Okay.
Yeah, I mean, from my own point of view, I think there are issues around what the capacity of that arrangement would look like and what would the cost be as well. And just to go back to what my colleagues have said previously, I would certainly urge, Lord Chair, if it was at all feasible, a visit to look at the levels of professionalism and rigour that are applied to existing processes that, in my view, work very well.
Can I just finally ask you then, do you think there are any authorities at all that should be outside, put outside of a warrant system?
So can I just clarify the question? I think we might be saying that a warrant system wouldn't be appropriate or necessarily appropriate.
Yes, hypothetically, if there was a warranting system, are there authorities or public bodies that should be exempt from the warranting system? If hypothetically there were to be one.
It is difficult to conceive of why there should be a differential approach if the considerations are the same.
Okay, let me perhaps ask a slightly different question. You quoted, Mr Pearce, the 240 urgent cases, threat to life, kidnapping. I think everyone in the committee would accept there's an urgent need to get information or to pursue those with the utmost speed and rigour. But would you draw a distinction then between a basket of cases like that and possibly tracking down paedophiles and perverts where you're sometimes years late on the case and there doesn't seem to be the urgency?
I think there's two things. I mean, firstly, there's the nature of whether you've got a reactive investigation or proactive investigation. Significantly for us, where a large number of our investigations are drug-related, it is equally important to be able to dynamically go after numbers to enable us to identify and interdict a commodity of drugs before it hits the streets and before our people become vulnerable.
Yes, but you could draw a distinction between someone where there's a kidnapped victim or a threat to life and within 15 minutes you need mobile phone data, and a case where 24 hours would suffice if you're chasing a known suspect.
I think this is a distinction that's not uncommon in the exercise of a whole variety of different powers and procedures. There's the fast time and the slower time. And I think common sense dictates there's got to be a possibility of defining what is appropriate for fast time, for example, life at immediate risk, or loss of opportunity if it's not done very quickly. So I think it's possible to make that distinction. It is analogous to other powers and processes, but I couldn't tell you exactly what it should look like in these circumstances.
I seem to have opened a can of worms here, Mr Mosley.
We've been talking about a warrant system before the search, before the request goes in. Would you have any thoughts on a notification process afterwards? If someone has been has had some sort of search done against their communications data, should there be a notification process that they are told about it later, maybe with some sort of court process in there if for some reason you wouldn't want them to know that because of an ongoing case?
I mean, I'm happy to just follow up on the previous point. I wouldn't want you to assume that I think this is possibly the best way forward, but if you impose this kind of process, then again, the analogy is already there. Where people exercise powers in fast time, there is a process of accountability to make sure that there's the same scrutiny applied, albeit retrospectively, because that's necessary. So I think the analogy carries through to that. So I think it would be possible to have some retrospective scrutiny of powers exercised in extreme circumstances of urgency.
Mr. Brown? Oh, sorry, Citizen Commissioner?
At the risk of disagreeing with my colleague, I'm sure we're agreeing in some respects, but I do think there are a very, very high volume of cases involving long-term covert operations where we may or may not be successful in the first instance in bringing somebody to justice, where we would actually probably fight quite hard not to have to reveal the fact that they were the target, whether it's in a counter-terrorist operation or an organised crime operation. And it would, I think, actually be, but I'm no legal expert, I think it would be a bit of a departure in our legal system.
I think there's sort of some cross-purpose on this. Peter's been referring to where an authority has been granted. Do you in some way notify some kind of body, like the Information Commissioner, that has taken place, which happens certainly in relation to Police Act and RIPRO authorities now with the Office of Surveillance Commissioner. I think the other point of your question was, is the member of the public who was subject to that entitled to have that information that a request had been made available to them somehow? I think it is more challenging, as Cressida has said, that investigations do ebb and flow, and therefore you may well compromise an investigation against that individual or others, and that provides a risk. There are means, and I think it is discussed even in this legislation, in terms of proposed legislation, in terms of what's the role of something like the Investigatory Powers Tribunal, which exists. In other jurisdictions, this does take place, and talking to colleagues in those other jurisdictions, they find it operationally challenging.
Mr. Brown, and then...
Chair, can I just say I'd like us to take up the suggestion of a visit to see how particularly how the authorisation system works in practice. I mean, I think that would be a good thing for us to do. But can I ask, how much of a practical possibility is it to improperly obtain information, you know, either for personal use or just out of curiosity from the system? Can operators do that, or would they be immediately caught and prevented?
My own view is it's practically almost impossible. In that, when if you're the applicant, you have to apply with an intelligence case which relates to a real case, a real operation, real people, real data that you are seeking. And then the supervisor has to look at that and make sure that what you're looking at and asking for exists and is a legitimate thing. Likewise, the point of contact and the designated person. And if you then ask, could the designated person do that or the point of contact do that, the answer is no, because there are these different sort of legs of the chair, if you like, who are all looking at each other and saying, well, what is this case?
Yeah.
So
is it a physical possibility to bypass that and get the information anyway?
I would suggest not, and indeed as our IT systems get more sophisticated, you can actually put algorithms in which will actually identify anomalous behaviour. And we should all, around our information assurance practices, make sure we're able to carry out those sorts of audits. So I think there are a range of protections, from the application and the authorisation process itself, the separation of those roles, the reasons for acquisition, added to the technical measures which are in place to check for anomalous behaviour.
I think that's the key point. If you're saying, is it theoretically, physically possible?
That is what I'm asking.
Then the answer to that must be yes, from my perspective, in relation to the designated persons who are the trained people who are authorising this. However, the systems that are in place would almost certainly ensure that if they did so, they did it once, and were caught immediately. because there would be the cross match in the audit trail that just would not exist.
Okay.
Thank you, Lord Chair. Just to look at the approach for warrantry again, we've looked at the issue of urgency versus non-urgency, and I think we all accept that there is a difference there, and by the type of case, where clearly a murder is very different from the sort of speeding offences that the Derbyshire Chief Constable seems to think count as serious enough to use this for. What about the option of separating it by the type of data? Because I think, at least some of you have indicated, I think it's true nationally, that most of the requests are for subscriber data, effectively reverse directly lookups, which I think would, to my mind at least, be less intrusive than asking, and who has somebody rung over the last 12 months and exactly where were they when that happened. Would it be a possibility to have warrantry only for the more intrusive types of request and to, for example, leave subscriber data requests under the current system? Would that satisfy many of your concerns?
I think, hypothetically, you could slice it different ways. Urgency, certainly. Seriousness, certainly. Intrusiveness, certainly. You could try to slice it in all those ways, or in some combination of those. I have to say, we believe that the disadvantages and the disbenefits of that, given the strength of the system that there currently is, are very great, and it would be difficult to justify for us going to that system, which would undoubtedly be a lot more costly and potentially burdensome.
Thank you very much. This is fascinating. We're learning a lot. We do need to push on. Lord Fox.
Yes, permitted purposes, which are contained in the draft bill, they have their origins in RIPA. It's quite a long list, and criticism has been offered of the fact that it is a long list and potentially puts the basis for obtaining information rather widely. I'd like some comments as to whether you think it's too wide, and perhaps we could have some assistance on which of the permitted purposes currently are most often relied upon. I don't know whether you've got the list of permitted purposes available.
Well, I can give you a very quick answer.
Thank you.
99.5% of our requests are for prevention and detection of crime. 0.5% are for the assessment and collection of tax or duty. That 0.5% is, I think, 69 cases in 2011.
And certainly from a policing point of view, primarily it's for the purpose of preventing and detecting crime or preventing disorder, and secondly for the purpose in an emergency of preventing death or injury or any damage to a person's physical or mental health. I haven't got the statistics, but I could provide them to you.
But all the many additions to those core permitted purposes, are those used regularly? Is anybody aware of them being used?
Not from my perspective, but I'm sure others in the Home Office may be able to provide advice on that.
Should there be any difference between the types of data that you can request and the appropriate authorisation system? There has been some suggestion that maybe there should be a distinction between, say, serious crime and non-serious crime, however difficult that is, in fact, to define. Does anybody have any views on that?
I think it's trying to define serious crime, which is very, very subjective and would be difficult to ensure any sort of clear and unambiguous interpretation. Working with the Communications Capabilities Directorate, we're introducing systems across the country to retrieve data in a more consistent format, which I think again will help a contextual understanding of the overall situation, and also to try to reduce costs and also reduce the numbers of mistakes that may be being made at the moment. But it's subjective and ambiguous.
Thank you very much. Lord Jones.
Lord Chairman, misuse of data and monitoring. And we want to ask you what level of monitoring and inspection occurs within your organisation to provide assurance to senior officers of the integrity of the SBOC process. And we're asking you, how frequently has your organisation been inspected by the Interception of Communications Commissioner? And how long did each inspection take? And what records were inspected on those inspections?
Well, the accredited officer role within our units is regarded as a gatekeeper. And I've said previously, sir, that 20% of applications, or just over 20%, are declined by our single point of contact. And applications can be declined for a number of reasons, which are proportionality, collateral intrusion and necessity. And once we've actually had the first look at the application, that then goes on to a designated person, and we also have refusals at that point. All of those applications are recorded onto a system and are available for audit and inspection. We have an annual inspection by the Intersection of Communication Commissioner, and that concluded on our last one that the accredited officers were performing their guardian roles and gatekeeper duties very effectively. In the last inspection for Kent and Essex, there were 5 recommendations that were made, and I could supply a copy of those recommendations to the committee should you feel that would be useful.
Excellent, good thing. Anything else, Lord Jones?
Yes, I wanted to ask the panel chairman what lessons were learned from the inspection, from the perspective of those who are giving witness today.
Clearly, I haven't got at hand the exact recommendations from the last inspection, but we're happy to share those with you, and indeed the action which has taken place consequent to those. Can I say, in addition to the range of management and supervisory responsibilities which go with this in terms of this, as a non-departmental public body, SOC also is required to abide by the Cabinet Office guidelines in relation to information assurance, which itself is very rigorous, and indeed having a senior information responsible officer within that process ensures that we look at the whole notion of how we manage our information and the assurance of it in line with the best practices which we report on once a year. So in addition to the Information Commissioner specifically looking at either interception or communications data issues, we also have this oversight in terms of how we manage information more broadly.
Lord Armstrong. Oh, sorry, Mr. ACC Beautridge.
What I could say is that the inspections are very intrusive. They last 3 days. All records are looked at. Officers are spoken to. Different roles and responsibilities within this process. These officers and staff are spoken to as well, and it's a very full report and debrief that results.
Thank you.
If I could just say for the Met, we also have, as you would expect, the Interception Commissioners there at least once a year. They come for a week or more in a large team. They are very intrusive indeed. They spend a lot of time with the staff, but they also examine a very high volume of records. I think in our case it's sort of getting on towards 1,000 records they've actually looked at physically. They discuss their findings with us and including with an assistant commissioner, and they make recommendations. In our case, and most recently, they've identified some systems issues and some administrative issues. They also have identified a couple of errors, and I think they're useful to outline. Whenever we have an error, which we ourselves find, we must report it, and we do to the Interception Commissioner, and then we have to have an action plan about how we put that right. 2 errors that they highlighted to us were where we had sought excess data, more data than we had intended. And the reason I give that example is because what the officers did was destroy the excess data straight away, which you might think was the right thing to do, but actually it's not what the codes of practice say. But they were so concerned about it, they destroyed the data and immediately told the Interception Commission.
Thank you for that response. The impression given is that you demand integrity, and very largely, as far as you know, you're getting it. Yes. And that integrity is a huge priority in your operations, in your given departments.
Absolutely. That's good, thank you very much. Lord Armstrong.
It was about defining serious crime on non-serious crime, but I think there would be people outside who would suggest that there are some crimes, there are some non-serious crimes for which access to communications data should not be allowed. How would you... we were told, I think, that 17% of police communications data requests were for non-serious crime. It would be interesting to know whether other witnesses would report similar figures. Would it be possible to devise a system which excluded, if people were worried about this, the use of communications data in relation to non-serious crime? I mean, bicycle theft, or something like that. If one said that one would not use this intrusion for non-serious crime, would that be workable? And what would you think about it? I think this applies particularly to the police.
Yes,
police of our nation.
My view is it is potentially workable. I would give two caveats, though. Sometimes a crime which is in a category which appears on the surface not to be so very serious, and I think I'm right in saying that burglary does not feature in many descriptions of serious crime, of course can be extremely impactful and very serious for the victim, and may be part of a serious series in which we fear what might happen next. And that, therefore, you can imagine a circumstance, and indeed sometimes in the Met we do give authorities in relation to burglary, where the degree of harm is so very high that we regard it as now a serious crime, even though it is not in that category. And to take the driving example that Dr. Hilbert referred to, it is not unusual in the Metropolitan Police for us, after a fatal collision, to make communications data inquiries. Now, I'm sure nobody would normally refer to that as just a driving offence, but if there was an offence, but it will feature in that category potentially as under driving. But I think most sort of members of the public would expect that if there's been a fatal collision, we will check to see that the driver was not texting or on the telephone at the point of collision.
If I might just follow up on that, I think the difficulty is in defining what's serious and what's not serious. One way of doing that is to look at whether the offence is triable only at magistrates' court or at Crown Court. I'll give you an example of why that's difficult. You may have heard of people who are internet trolls, who spend a large amount of their time inflicting serious psychological harm on people through, for example, posting inappropriate messages or photographs on tribute sites to recently deceased relatives. The appropriate offence for that is under the Malicious Communications Act, which is triable only at the magistrates' court and is subject to time restrictions already. I think most people, certainly people who are affected by that kind of crime, would regard that as serious, and of course it's in the nature of it that it's very difficult to investigate without communications data. I'm not arguing for that to be included, I'm merely observing how hard it is to draw a firm distinction between that which is serious and that which is not.
Magistrates' courts has been mentioned several times this morning, and I think there are two, the district judge, the stipendiary, and the time-honoured 3 magistrates. Which would you prefer? Do you have a preference? Do you ask for one or the other?
If I may just clarify my answer, that my point about it was more about the way the criminal law categorises malicious communications. I wouldn't wish to express a preference personally, but colleagues may have been.
Thank you very much. Any other points, Lord Armstrong? No. Can I conclude with a couple of questions? Assistant Commissioner, you did mention the one would need, in certain cases, in less serious crime, to check on whether one was texting or using a mobile phone on the motorway if there was a road accident. Well, I confess an interest in that, having been Police Minister, my admiration for the work of the police service is second to none. And there are 3 constables in the Lords whom I have tremendous respect for, Condon, Deere and Stevens. But having said that, I'm also cynical that give the police a power for one thing, and there is function creep. It gets extended to other areas. Within minutes of the Home Secretary at a press conference saying this is necessary for terrorism, paedophilia and serious crime, I think Mr. Mike Creedon said, and of course if there's someone on the motorway zooming along at 85 miles an hour texting, that's a threat to life, so we need to get that person too. So would you accept that it does add to the cynicism of some of those who are opposed to this bill, that whilst we talk about terrorism, paedophilia, serious crime, there is a fear that if the police get this additional power or the additional information, it will then be used to pursue other areas of crime which are not in that category of top level? It's an unfair question, but life isn't fair. Yes, sir.
May I was present
That's correct.
at the press conference, and my recollection of what Chief Constable Creedon said, and of course he's not able to answer for himself here, was in the context of using communications data to investigate fatal or serious road traffic collisions, and that's an investigative staple. I appreciate your point, and I understand it, but I just thought it would be useful to... My understanding of what he was saying was more around the very serious consequences, which are to be prevented and avoided, if at all possible, of people misusing communications devices while they're driving what are actually potentially lethal machines.
But, okay, that was not quite my recollection, but let's not argue about it. What assurances can you give to prevent police function creep? If you've
First assurance, I think, is actually how it is being used now, and we've discussed that in some detail. The degree of seriousness that we as senior people regard this with, the systems that we have in place, and the safeguards that are very properly there through, for example, the Commissioner coming to visit us. I suppose, you know, it isn't obviously for us to say what police powers should or shouldn't be. And where they should be limited. And I take your point entirely that intrusive powers should only be used when they are justified. And where that line should be drawn is a matter for Parliament. Rest assured, however, that whatever we end up with, we will try to our very level best to ensure there is no creep, and we will invite inspection, and we will be happy to have safeguards.
Thank you very much. Can't say fairer than that. Final query, ACC Beautridge. This snapshot, I was under the impression that the statistics you gave for Kent already covered all of the breakdown, what is sexual offences less serious. Why is there for a 2-week snapshot necessary in the country if you and all the other forces are providing this information?
We wanted to make sure that there was a national picture that could be presented that looks at the number of applications, what they were for, and different categories of the applications as well, so that we could derive meaning from all of the data that is out there at the moment. There is a huge amount of data. I think the requirement for some analysis to derive some collective meaning is very, very important in the context of where we are, which is why we commissioned the study.
Thank you very much. We look forward to looking at the data from all the forces on the national snapshot, and we'll make them back to this. Assistant Commissioner, gentlemen, thank you very much. We've gone on longer than intended, but it's been very worthwhile. Thank you very much. Order, order. We'll reconvene with the second panel of witnesses. Thank you very much for coming. If I could briefly ask to state who you are for the record, starting with Mr. Thompson.
Daniel Thornton. I'm the head of legal in the Enforcement and Financial Crime Division of the Financial Services Authority.
Excellent.
Councillor Paul Bettison. I'm the lead member for regulatory services at the Local Government Association.
Thank you very much.
I'm Gillian McGregor. I'm the Director of Operational Intelligence in the UK Border Agency.
Excellent. Thank you.
I'm Nick Tofiluk.
I'm Director of Regulatory Operations at the Gambling Commission.
Thank you very much. Thank you for coming. Sorry we're starting slightly later than planned. We had a lot of information to collect in the last session. Can I begin by asking each of you some very brief starter questions? First of all, how often have you made requests for communications data in the past? Can each of you give us an answer, please, if you have it?
Well, as I understand it, we are, in fact, the largest non-core authority in terms of the use of communications data. I can give you the statistics for last year, where we had 2,375 requests, of which about 65% related to subscriber data and about 35% related to more intrusive forms of communications data. Most of that was for the purposes of insider dealing criminal investigations, which, as you will understand, is effectively an information crime. So it is all about the passage of information, which is why communications data forms such an important part of our investigations.
Thank you very much. Councillor Bettison, just the numbers.
Yes, sir. Well, of course, the Local Government Association itself is a membership body, and therefore we never request communications data directly from the LGA, as we have no requirement so to do. However, our individual member councils can currently request communications data, but only for the purpose of preventing or detecting crime or preventing disorder. Of course, these crimes are often targeted at the most vulnerable in our communities, including rogue traders, loan sharks, doorstep crime, antisocial behaviour, environmental crime, animal welfare issues and benefit fraud. But the LGA itself doesn't collect data on the number of requests for communications. We leave that to the Interception of Communications Commissioner's Office. The annual report from the Commissioner's Office indicates that all requests received from councils only make up 0.3% of all data requests. And we believe that this low figure shows that councils are exercising their powers in a proportionate way and only requesting data when absolutely necessary.
Okay. Thank you very much. Ms McGregor?
Well, for the border agency, our figures are that we accessed, in 2011 we made 4,062 access requests. The border agent, just to clarify, the border agency figures are included within the General Law Enforcement and Security Agency figures in the IOCO reports. Now that's an increase on 2010 when we submitted 2,854 requests. And we anticipate that this year the figure will be higher, and I think that reflects the fact that the agency has taken on a much more central role in terms of the investigation of serious crime in relation to immigration and border issues such as drugs, importation, facilitation and trafficking.
Okay, thank you. Mr Tofiluk.
Because of the numbers are so much smaller for ourselves, being a relatively small organisation, if I put it in the context of 3 years, we made 104 applications over the last 3 years, which averages 35 a year, which resulted in 636 requests. 68% of that was for subscriber data, 24% was for use, and 8% was for trafficking.
Excellent, thank you. I think you've each told us what types of data you've tended to request. Was anyone?
I don't think I did.
No.
If I could just clarify, our breakdown is that for subscriber data, our percentage is about 70%. For user data is 5%, and for traffic data is 25%.
Excellent, thank you very much. And briefly, each of you, under which permitted purpose in ARIPA have most of your requests been in the past, for permitted purposes?
All of ours have been preventing and detecting crime because they've been for the purposes of criminal investigations. But I just put a slight gloss on that, which is one of the new permitted purposes under this draft legislation. We also investigate civil market abuse, where we can impose a civil penalty. Those powers actually come under the Financial Services and Markets Act and come from a European directive. Now, the proposal in this legislation is that instead of using that power, the power is streamlined under RIPA or RIPA type processes to use the same sort of process. Now, in fact, we use exactly the same processes for using our FISMA powers as we do for using our RIPA powers. So that is the breakdown of how we use it under the Act.
Excellent. Thank you. Councillor Bettison, as far as you know.
All of ours are and will be for the prevention or detection of crime or preventing disorder.
Yeah. Thank you very much. Ms McGregor?
Over 99% of the border agency purposes for the prevention and detection of crime. Mm-hmm. We also have a very, very small percentage which relates to our statutory responsibilities in detention services relating to public safety. In relation to the maintenance of good order and discipline on the detention estate, but also the prevention of escape and riots.
Of course, yes. Mr Tofiluk?
The prevention and detection of crime.
Excellent, yep. And what kinds of investigations, as far as you can tell us, do you use the communications data for?
Well, as I said before, most of it relates to insider trading investigations. So those are principally about someone trading on the basis of inside information. There is often quite a long distance between the inside source and the person who's actually dealing. It's a form of organised crime in that we see groups or rings of people who pass data between them, and therefore communications data is key to trying to work out what the connections are between the person who traded and trying to work out where the inside source is. So that's probably the principal means by which we use this data. It also is important for market manipulation. For example, people posting messages on bulletin boards to try and move a stock price and then trading on the back of that. That's one of the abuses we've seen. We also use it in the unauthorised business area. That's people who are trading without authorisation, which is a form of fraud, effectively, in that they're selling worthless investments to vulnerable consumers. We use that often to try and be sure that who is actually calling the consumer. So, for example, a lot of these people will use false names, so it's often important to try and work out who actually is making the call. We've also used it in a similar investigation to actually track down where a boiler room was operating from. That's a group of criminals pressure selling worthless investments. And we actually used that to locate where they were operating from using internet data, for example, and therefore executed a search warrant at the right premises.
Thank you very much. And Councillor Bettison, you give us some examples. Could you sort of rank them in order of the most used?
Well, I think so. It's probably these days the most used is the question of benefits fraud. And we know that it is the government's message to benefit fraudsters that it's not if we catch you, but when. And certainly the use of these powers help us to help the government make good on its promise.
So I presume that would be in housing benefit at district council level, rather than county council.
That's right. Yeah. Again, as Mr. Thornton has said, it's very much a question often of tying in somebody who has given a false name or no name on a communication with someone, certainly in the realm of rogue traders as well. Yeah, that's another very large use that we would use, bearing in mind, of course, how little we have to resort to it. But on those cases where we do have to resort to this sort of information, it is absolutely vital, and I have a number of case histories which I'd be very happy to supply in writing, if that would be useful, where conviction has only been possible by this type of information being available.
And would you be able to give us an assurance that some of the cases we've read about will no longer occur, such as a parent being checked up on for their area their school child lives in or whatever, which would seem to be an abuse?
Yeah, we are very conscious that, due in no small part to the activities of the national press, these very, very rare occasions make make much bigger stories. And the reality is that the public therefore need reassurance. And that is why we're very happy indeed to continue to work under the extremely stringent regulation that we have to abide by in order to access this information.
Thank you very much. Ms McGregor.
Well, in the border agency, we use communications data for quite a wide range, but if I was to rank them, as you requested, I think the most common use would be in relation to drugs smuggling and the smuggling of prohibited items, which of course is something that we are responsible for in the agency through customs and our customs colleagues who have joined us. Also facilitation and organised people smuggling, so including trafficking offences for bonded labour, for vice or for vulnerable persons, including children. But we also use communications data for other immigration offences, such as the use of forged documents, counterfeit documents, and organised crime groups that might be involved in that sort of activity, and for other issues such as sham marriages, colleges which are bogus, so a number of different things. But in that order, I would suggest is the kind of ranking of which communications data would be useful.
Thank you very much. Mr. Tofiluk.
In the case of the Commission, overwhelmingly 79% of our applications are focused upon the offence of cheat, but if I could put that in the context of something that's perhaps more recognisable as match fixing and all that entails. The Commission is the lead for the intelligence function with colleagues from ACPO, with sports governing bodies and with betting operators to address this threat. But that involves the corruption of betting markets, the facilitation of those prepared and able to manipulate sports events as well as betting events, predominantly online betting, and it also involves the use of inside information, and so there's a lot of similarity with colleagues from FSA here. 17% of our applications have been focused upon those illegally supplying gaming machines, which is a very lucrative pastime, if I can call it that, or enterprise, into possibly premises that are unlicensed for such, which has not only a criminal aspect but also relating to the Commission's objectives, which is preventing harm to children and young persons and the vulnerable, which we think is very important. And 4% relates to the unlicensed provision of gambling services. So that's very much weighted in terms of match fixing.
Thank you all very much. That's very helpful. Final one from me on the starter questions. You've all pointed out you're very low users. Why? Why aren't you using it a lot more? Maybe I'll start with Ms McGregor this time. Not you personally, but border agencies realise you've got a powerful tool here. You're going to double the intake of the access requests.
That we are making use of these powers daily, and our use is increasing. So, for example, I gave the figure for usage in 2011 of 4,062. I think we're projecting that for this year our figures will be in the region of 6,000. But we do have to make sure that what we are requesting is proportionate and necessary. So I think it reflects the balance between the role that we have, the central role as the law enforcement agency for this type of crime, and the proportionality of what we're doing. And also, of course, we have a very close relationship with other agencies such as SOCA and ACPO, and on some occasions some of our investigations will be so serious that they will be elevated to those agencies.
So is the proportionality hurdle for you in some ways too high? Are you being judged against the same yardstick as the security services, terrorism, the people trafficking, the paedophile police experts? Do you have to show the same level of proportionality chasing illegal immigrants as our security services do chasing terrorists?
Well, I think the proportionality issues are similar because lots of the investigations that we're dealing with are on a par with some of the serious investigations that the police and SOCA investigate. So I think our proportionality and necessity judgments are similar.
Mm-hmm. Any others wish to comment? Do you feel constrained? You'd like to use them a bit more if you could? No?
I think I echo it in a very great degree, and I think it takes on from the previous discussion about what we mean by serious, and towards the latter part of the previous session, the word harm started to feature in the discussion. And from the Commission's perspective, the licensing objectives very much focus upon crime, and then what I would start to think about harm in terms of children, young persons and vulnerable people being exploited by gambling, and then fairness. So proportionality for us is a combination of the criminal impact plus the wider harms. And also from the Commission's perspective, we have 200 staff in total, and therefore the ability to use the powers wisely in terms of resource efficiency, as well as our ability to use the data once we've got, is a constraint. But again, I would make the point that, as a colleague from UKBA has said, we work increasingly in collaboration on the more serious cases with police forces, with HMRC, and increasingly, because of the global nature of gaming and sport, we are increasingly engaged in international collaborations.
Right, Lord Jones.
Lord Chairman, future use of communications data. First question. None of the bodies on your panel here today are on the face of the draft bill. And this means that if you are to have access to the data, you have to be added by order, the parliamentary process. Do you wish to have access to communications data in the future? And have you been given any assurances that you will be added?
Well, we're not on the face of the bill, although one of the purposes under the bill, civil market abuse, is actually for an offence that only the Financial Services Authority can actually pursue, which could be said to be a slight contradiction. It's also, and the reason for that being there is actually that is in European law as well, in the Market Abuse Directive and regulation. So we think we have a very strong case to have these powers. Whether that's on the face of the bill or through a statutory instrument, I suppose doesn't make any difference to us per se, but obviously we have to go through a process to get approval from the Home Office, but ultimately how that's done is really a matter for Parliament.
Clause 11 of the draft bill and the recent Protection of Freedoms Act provide councils with the power to continue to access communications data with the approval from a magistrate. And this shows, we believe, clear recognition from government of the importance of these powers for councils to protect their communities from crime. However, since the bill was published, the Home Office have advised the LGA that we're expected to make a business case for a specific order to ensure that councils can retain access to communications data. And the change in stance, along with differing legal views about whether the order is actually required, has created significant confusion and concern about government intentions on the matter. And it would be helpful to have a clear message from government to support the importance of councils retaining access to communications data in order to protect their most vulnerable parts of their communities from crime, and also to acknowledge that councils are actually making good use of current powers and in a wholly proportionate manner, witness the very small number of uses currently.
Thank you for the information as to what the Home Office has said to you. Others?
Yes, well, as you said, the border agency is not on the face of the bill, and that reflects the position in RIPA, where our powers come from the secondary legislation. What I would say is I think that things have moved on for UKBA, and that we are recognised as a law enforcement partner with a very clear role. So certainly we want to retain the access to communications data, and as with my colleague Councillor Bettison, we have been asked to produce a justification for that continued access. And similarly, I think the most important thing for us is to retain access to the communications data, and whether that's through being named on the face of the bill or through secondary legislation, possibly a sort of secondary issue, but we certainly want to retain the access.
Mr Brown, you want to clear on this point? Oh, sorry.
Just on this point, Chair, is it true for the FSA and for the Gaming Commission as well that you've been asked to prepare for draft secondary legislation?
We've been asked to provide data to the Home Office and to present a business case as to why we should have access to communications.
And that would be, is that so for the gaming? Well, why don't we
What's the
seek
deadline for that?
Why don't we seek a list of the organisations that have been asked to prepare for this eventuality? And that might tell us something we don't know.
Yeah, I agree entirely. We shall request that. What's your deadline for producing your business case? Are they all roughly the same?
We're supposed to produce some data, I think, by the 20th of July.
Yes, that's the same.
20th of July.
20th of July. So you require to produce some data or the business case, your justification for having an order made in your favour. And you'll provide that full evidence, data, justification by 20th July to the Home Office.
That's right.
Excellent. Good. That's helpful. Lord Jones, did you follow up? Sorry.
Very brief question following up. What would be the implications for you if you were not to have that access to the data you wanted? Can you briefly tell us?
Yes, I mean, that's somewhat speculative, but certainly in insider dealing investigations, I think very many investigations would never get anywhere. Insider dealing simply wouldn't be detected. We'd see suspicious dealing, but we wouldn't be able to identify whether it was innocent or not. Most of our criminal insider dealing prosecutions, communication data has actually formed a central part of the evidence. It is, as it's about the passage of information, it is an offence that you prove through circumstantial evidence. And one of the most important parts of circumstantial evidence is the timeliness of communications and who is calling who when. So you have the insider calls somebody who then calls somebody else, who then calls the dealer, who then immediately places a trade, for example. So showing that pattern of behaviour and patterns of calls is absolutely central to most of our prosecutions. So if we didn't have access to this data at all, it's likely that many crimes which we currently prosecute, we would not simply be able to prosecute at all.
Thank you.
Do you think you ought to be on the face of the bill? Would you prefer to be on the face of the bill?
Well, I prefer not to have to make a business case, if that's what you mean.
Well, you might have to do that either way.
Well, yes, either way. I mean, as colleagues have said, for us, the important thing is to have the power. Exactly how it's portrayed in legislation is really a matter for government and Parliament.
Thank you. I think that not allowing local authorities these powers, it would leave councils without the necessary tools to protect their residents and their businesses. And it would undermine the government's message to benefit fraudsters about, it's not if we catch you, but when. I think it would seriously undermine that. At the moment, there have been a number of high-profile cases where benefit fraudsters have been caught, identified and dealt with. And it is important that people understand that benefit fraud is not an easy way to win on the system, and this make sure that they can't.
In your experience in local government, are there many benefit frauds? Is it very serious?
I think, my Lord, the nature of that particular fraud, that is stealing from everyone. And as such, it is if we're not careful, it can become, or it could become, one of those victimless crimes, simply because we can't identify everyone, because we all, as taxpayers, are the victim of those crimes. And I think it is very, very important that councils are seen to have the ability to find out if people are cheating the system and to stop them doing so.
Would your business plan include evidence that there are many cases?
It would include the details of, such as we have, of the magnitude of the problem, and also include examples where the problem has been dealt with by the use of this data communications information.
Ms McGregor, anything to add?
Well, similarly for the border agency, I think if we did not have access to this data, it would seriously hamper our ability to investigate immigration and custom crime, particularly the serious crimes. The very nature of the crimes that we're dealing with are international, they're fast moving, they involve communication across borders, So we rely heavily on communications data. And just to give a flavour, in 2011, we conducted 461 separate criminal investigations which involved access to comms data.
Thank you.
If I may, I'll return to the previous question as well, because I didn't answer on that one in terms of would we expect to be included on the list, and I have to say I would be extremely disappointed if we were. Whether it was by virtue of statutory instrument or on the face, I'm less bothered, if I can use that common term. We were given powers under regulation and criminal prosecution, and as such, I think that's totally consistent with what's expected of us as the Gambling Commission, our core purpose. If I can very quickly say that if you think of our core purpose in terms of regulating the gambling environment, a large proportion of that gambling environment is now moving to a remote basis. Indeed, the global gross profit of remote gaming is increasing year on year. And the second part that makes the case for me in terms of our regulatory and associated possible policing, if I can call it that, of that environment, is that in perhaps 2 years' time, the licensing arrangements for those providing remote gambling to UK citizens will change, where we will have to license those at the point of consumption or providing to UK citizenry where we presently don't have to, which is likely to increase the traffic, the market traffic in gross profit terms by 5 to 6-fold in my estimation. And therefore, being able to understand and retrieve data from a remote environment where not only the scale of gambling but the technology that supports gambling is fast moving is absolutely critical. If I can finally say that in terms of our role in the lead for sports betting corruption, match fixing, without the powers given to us under RIPA, I would go so far as to say I don't think we would be able to perform that role.
Thank you very much. Mr. Ellis.
Thank you, Lord Chairman. First of all, Councillor Bettison, if I may. Now, local authorities are, they request traffic data from service providers. They cannot do that, whereas other bodies represented here can. So the draft bill replicates that limitation as far as local authorities are concerned, and further states that local authorities will only be able to request information that the service providers continue to generate out of business need. So this may be as a result of a perception in some quarters that local authorities have been responsible for frivolous applications. So I would like to give you the opportunity to say whether you think that this limitation poses any problems for local authorities, and can you make a case for wider access?
Thank you. In terms of making a case for wider access, then I'm sure that, given due warning, yes, we could. But as I mentioned at the outset, the Local Government Association itself does not collect data on the actual usages from its authorities. On behalf of the local authorities that you represent. As to whether or not we could use additional, I'm sure that we could find cases where it would have been useful. Having said that, I'm here today quite content with the powers that we believe are being offered to us, and not demanding greater powers. And certainly, I would like, if there were any way in which we could gain assistance in dispelling any myth about our limited powers being as a result of frivolous activities in the past, because I don't believe that to be the case.
Right, thank you. So the other bodies here represented can request all types of communications data, including traffic data, I think I'm right in saying. So how often do you request traffic data, each of you who can? And what kind of investigation is traffic data most useful in?
Well, the first stage is often to get the subscriber data, so to work out who's calling who. But traffic data or use data is essential to work out the timing and length of telephone calls, for example. Some investigations have been, it has been important to work out where people are at particular times. Or indeed the use of when they're logging on to, say, a secure internet site which is being used to deposit information, for example. So our usage is probably between sort of 30 to 40% per year is probably for the more intrusive forms apart from subscriber data.
Ms. McGregor?
For the agency, we rely heavily on traffic data, so it forms about 25% of our data requests. And I think the cases that it's particularly relevant to are the trafficking, facilitation and smuggling offences, where similarly to colleagues, it's very important to be able to be aware of movements, to know who's been talking to who and how that's progressing. Right. So about 20, and we do have, if it would help the committee, we would be very happy to share some examples of cases where traffic data has been particularly helpful in achieving a
yes, indeed.
conviction.
Could you give one brief example now?
Yes, I could. We dealt with a major investigation into a serious organised crime group operating in Manchester, which was importing drugs. And for that particular investigation, we used a mix of all the different types of communications data, including cell site data, through which we were able to track the movements of suspects, and linking that to other information to place them in a position where we understood that they were the people who were operating the organised crime group. And that involved, and just to give you a view of the scale of the operation, that involved drugs, Class A drugs, heroin, of a total weight of 175 kilograms and a street value of 13.5 million. And the two people who were the main members of the organised crime group were sentenced to 11 and 9 years in prison, respectively. So traffic data was very important.
And to the Gambling Commission, important?
Very, in almost exactly the same circumstances as my colleague for the FSA, because, as I said previously, what we're trying to do is prove the connectivity between facilitators that can influence sporting events, not just the result, but incidents within a sporting event, and the placing of bets and the communication between those people that are connected in that type of manipulation of the market.
So that those of you who can utilise traffic data at the moment feel that you need it, and you'd be at a serious disadvantage if you were restricted from it in the same way that local authorities currently are. Is that right?
Yes.
That's right. And what percentage of communications data do you feel that you need for your own investigations that's no longer available? We've heard about a degradation from 95 to 100% many years ago, down to 75%. Can you say something about the lack of this data and how it's affected your investigations? Do you agree that there's no longer as much access to data for whatever reasons as there used to be?
I think it's very difficult to say. We find for our investigations that we do get quite close up to the 12-month time limit because of their complexity. It's rather like an onion. You're peeling layer after layer to work out the connections, and by the time you get to where you really want to be, you're hitting the end of the period which we know telecoms companies keep material for. So that's a definite limitation. But what I suppose we don't know is the extent to which more sophisticated means of undetectable communication at the moment are being used. We're certainly seeing in our investigations more sophisticated techniques being used, pay-as-you-go mobile phones, for example, but also using self-destruct USB sticks to store sensitive data on, which are passed between people, for example, and use of secure internet sites as a way of passing information. So certainly the people we're tracking are becoming more sophisticated in their techniques.
Self-destruct USB sticks?
Well, these are where you have hardware encryption, so that if you enter the wrong password 3 times, it actually destroys the data.
I see.
So they're very...
It's not like Mission Impossible.
Almost.
Any other comments? Can I jump now to Lord Fawkes, because I think you have a time constraint, and then Lord Armstrong.
Yes. Costs. Do you think that the ability to access communications data reduces the amount you'd otherwise be spending on investigations? In other words, is it a significant cost-benefit that you have this access or not?
I think, again, I find that a very difficult question to answer because it's a unique and central tool. So it's not a question of having an alternative technique to get the same information. I think the premise of the question doesn't really work for our sorts of investigations, because the position you would be in is you simply wouldn't be able to detect the connection at all, rather than actually have an increased cost to try and find it.
I think from the Commission's perspective, that's similar in the case of looking for the organised crime related to match fixing and insider information, but in the case of perhaps more what you might call bricks and mortar type of investigations, consequence may very well be that our only real alternative would be to use some form of directed surveillance, which would possibly add tremendously to the cost, and I have personal doubts as to whether it would be that effective, and I suspect it might be even more intrusive than perhaps our current mechanisms.
Or cost in terms of manpower?
Absolutely.
Yeah.
I think similarly for the border agency, it's quite difficult to quantify, but I think there are two angles to this for us in terms of cost. One is very similar to my colleague from the Gambling Commission, that I think if we didn't have access to this communications data, we may need to consider more resource-intensive direct surveillance activity, which would be very time-consuming, costly, resource-intensive. And I think also that we would have to carefully consider whether we investigated certain serious crimes, which has
because you didn't have the resources.
Because we didn't have the resources, and that would, that brings its own cost, both in terms of the cash seizures that might follow a successful prosecution, but also in terms of just the general cost to UK PLC in terms of increased crime. So we have a two. It is difficult to quantify. We could attempt to do that if the committee would find it helpful, but it's quite difficult to quantify.
We don't carry the data on that at all, so I'm not able to assist, I'm afraid.
Yes. All the discussion so far has been about the use you make of data obtained under RIPA and your desire to not lose access to that. But you will be aware that this draft legislation substantially expands the range of data that would be available to public authorities. Is there any of that expanded data, and if so, which, that you feel would improve your ability to do your job?
Well, perhaps if I start on that, I think that my view on that is similar to my colleague from the FSA. I mean, in a sense, we don't know what we don't know, but our sense is that the serious criminals that we're dealing with on the immigration and customs side are making increasing use of more sophisticated internet and smartphone techniques to communicate. So I think it would give us, potentially give us more options. But I think that, the same proportionality and necessity considerations would apply. So, I think in the agency, we're looking to retain the ability to be able to keep up with the communications that the criminals that we're dealing with are using. We want to retain that, and we understand that because technology is progressing, that the current information is perhaps not the whole story.
I think from the Commission's perspective, if I may, I agree with the sophistication of those that perhaps we're trying to find in disguising their footprint, as it were. But from a Commission's perspective, we're entering an era where the remote gambling platforms are of increasing sophistication, not least of which because of what we call peer-to-peer gaming. A global internet room means that communication is taking place not only through different technologies now, but over international boundaries. And when you're looking at the potential for things like money laundering through techniques that you can enable through the peer-to-peer gambling or the playing through exchanges, in one sense, we don't know what we don't know yet, because we're in a process of discovery exactly what techniques are being used to pass information, what technologies are being used, what's the fundamental difference. And this, I think, is going to pose as much of a challenge for us to define what that is to CSPs, so they know to look out for it, as it is to describe it to ourselves, to capture it. So I think from a Gambling Commission's perspective, there's a period of dialogue coming where the engagement, possibly through ACPO and the communications group with the CSPs, about what is exactly the nature of the information that's now being transacted in what can broadly be called fraud, through gambling, we would start to need to define to capture.
Thank you very much. Mr Brown, are you on this point?
Well, I just wanted to return to the point about warrants. It's really just for Councillor Bettison. Are you able to tell us what proportion of warrant applications are rejected by magistrates?
No, but I'm sure we notice we would be able to come back.
Would you be able to supply that to the committee?
Sure,
Find that.
Thank you very much. Lord Armstrong.
Again, I think the answer will be different from Councillor Bettison, but how many, you have to have a designated senior officer to authorise an application. How many do you have in your organisation of these people? Are they solely employed on that, or do they combine that with other roles?
I mean, our processes are quite similar to other law enforcement agencies. We have a dedicated single point of contact and his deputy, who are both highly trained and work in a secure area, and they're the sort of first gatekeeper, if you like, for applications. The designated persons are heads of department in the Enforcement and Financial Crime Division, who are well used to managing complex financial services investigations and judging proportionality and necessity, which they have to do in their daily jobs in respect of how we exercise our statutory powers more generally. This isn't just the only intrusive power that we have into data. So that's how they fit in, and then the senior responsible officer is me. There are also lawyers involved in a lot of steps of the process. We have lawyers in the investigation teams. The SPOC is looked after by a lawyer who assists in any legal issues arising. And the majority of our heads of department are also lawyers, and I'm a lawyer. So we're probably a bit lawyer heavy, but certainly there's a great deal of legal oversight in the whole process.
Are your senior designated officers sufficiently detached from the individual cases?
Yes, it's you can't be a senior designated officer on a case that you are managing or involved in. So there is an independence from the investigation that's being conducted.
Councillor Bettison, this may be a difficult one for you.
No, it's slightly different perhaps, but and because the level of data requests submitted by individual councils means that it wouldn't be feasible to have an officer dedicated solely to approving requests for communications data. But designated senior officers, although therefore still an integral part of the service or legal support associated with the detection and prevention of crime, they are required by REPA to be designated officers, and they are of such standing within the local authority as a director, a head of service, service manager. So they're also, and also all REPA style activity is overseen by elected members. And so the as responsible employers, all councils ensure that these individuals are very, very well trained, although, as I mentioned earlier, it isn't their sole purpose in the authority to do this. But we do take it very seriously indeed, right up to having the final analysis, the elected members are responsible.
And the numbers of designated officers would presumably vary according to the size of the authority?
No, it would be one in most authorities.
One?
Yeah. Sorry, my Lord, I didn't answer that question. For us, it's 7.
Yeah.
Ms McGregor?
For the border agency, we have a very similar arrangement to my colleague from the FSA. We have a single point of contact, which is a very small unit, which is secure and brings in all the requests, which are then referred to the designated senior officers. We have 18 of these across the whole agency, so it's a relatively small number for an agency that employs thousands of people. They are all people who are regularly involved and highly trained in investigations and RIPA, but as with my colleague, there's a very kind of clear dividing line between the sort of case, an application that could be considered by the senior officer. It mustn't be an investigation that they're involved in. And we find that quite easy to manage because our agency is based nationally, so it's very easy to separate the investigation from the designated senior officer who would approve or otherwise the request.
As far as the Commission goes, we're very mindful that you might be involved in the war, but the rule is you're not involved in the individual battles. We have 2 fully trained single points of contact within a secure intelligence environment, trained through the National Police Improvement Agency and accredited to the same standards of police. We have 4 designated senior persons, one of whom is not the head of enforcement, to enforce that separation. All are trained, and 3 of those 4 have previous experience either with soccer or with police and have gone through training there and have had responsibilities in those environments. The senior responsible officer is myself, and the unit is led by the head of the intelligence, which has responsibility for wider information management as well as RIPA.
Thank you very much.
Thank you very much, Lord Armstrong. Dr. Havett, on this point? Yes, by all means, Mr. Mosley.
You've been talking about the internal monitoring. On the external point of view, could you just talk about the process that you've seen from the Interception Communications Commissioner?
We've had several visits, probably about every 15 to 18 months. He comes for, or one of his inspectors comes for 2 days and does a very thorough review, looks at many requests. We have always come out well, I think, from our inspections, in that all of the applications that he's looked at have been lawful, proportionate and necessary, and we see it as a very thorough process.
Okay, Dr. Hubbard.
Thank you, Lord Chairman. Can I firstly declare an interest as a Vice President of the Local Government Association? I would have to say I'm struck by what we've heard already, that despite the focus and the rhetoric on how powers would be to access data would be reduced down to 4 key organisations, it seems you've all had a number of discussions with the Home Office about expanding it back out again. I can see how these things balloon. But can I firstly ask to the Local Government Association, because you're on the face of the bill in the rather odd position of not being included, but having constraints on the powers that you could exert if you were to be included, which is a very odd position, whereas the rest of you, I think, are just not in the bill at all. Can I just firstly ask, do you support the fact that the warranting system was introduced, and are you concerned that it might put local authority officers off requesting data?
We're not concerned that they would be put off requesting data, because they request data basically so infrequently that it is already of such importance that if that is the price we need to pay, then we'll pay the price.
And you support the warranting system?
Yes.
Yeah. That I think is very helpful and very clear. Now, the rest of you, as I say, are in this odd position of not to be included on the face of the bill, but also not having any constraints. Given the relatively small number of data requests that you all make, it seems that just like the Local Government Association accept a warranting system, that could be made to work for you as well. Would you be comfortable with such a...
Because I think that the volume of our request is quite significant, and to introduce a warranting system, even if it was only for the more intrusive forms of data, i.e. not just subscriber data, would be quite a significant change, I think, from our processes. Now, you can judge whether it's necessary or not in terms of the robustness of our processes, but to have to go to a magistrate, it would probably be at least once every working day. For the amount of requests that we are putting through would be a quite considerable burden. Our other significant concern about introducing that sort of system is likely to be the delay that's going to be caused to investigations. I mean, we're not dealing, except in very exceptional cases, with very urgent applications. So it's not like going for a search warrant, for example, which can be done in a few days. We see that these might get to the bottom of the pile. So if they're going to take weeks, there's a very significant danger of significantly prolonging the investigations, and in fact us not being able to get access to data at all, because it will drop off the end of the 12-month period. So not to mention the sort of cost and expense of this sort of process. So it's not like we'd be doing one a month. It would be much more.
So any system would have to be prompt and efficient for it to work for you. What about the other 2 agencies?
I echo completely what my colleague from the FSA said. We have similar issues. Our volume of requests although it's a small percentage, I think it's about 1% of the total, it's still quite a significant number. And I think we feel that we would find it very challenging to operate the warrant system in terms of the capacity and cost of the system that might be involved, but also, as my colleague mentioned, in terms of the potential delay to cases, because a number of our cases, not all of them, but a number of them are requiring response to very urgent situations, including in some cases in relation to high harm subjects, and also in certain circumstances a risk to life, for example in trafficking cases or people who have breached the border and are dangerous.
Mr. Tofiluk. In terms of the volumes, our volumes are relatively low, and therefore I wouldn't be in the same position as colleagues that have spoken already. But I would ask, first of all, I think there would be a cost implication for us in terms of a small organisation. The issue of delay would be of concern to me, although, again, we're not in the territory of threats to life, but again, we would more than likely go through a central court in the centre of Birmingham, which may very well be having a lot of other requests, given the nature of the city and other organisations in that area. So the issue of delay. And then I suppose I asked the question, what value added would that add, not least of which colleagues from the previous session have said that we would retain our internal scrutiny and oversight. But I'm not questioning the principle if that's the wish.
But I mean, do you all accept that there is a fundamental issue about self-authorisation for powers versus external authorisation? You're presumably aware that almost every other country with a similar process has some form of third-party authorisation. Do you accept that principle at least?
I think, if I can, I think there's a question about transparency and whether we have faith in the arrangements, the oversight arrangements at the present moment in time, and that's not for me to answer as such in that sense. I make the point that if that's the will of Parliament, that there is a transparency through the courts, then that would be accepted, quite rightly. But the point I make, as I think police colleagues did as well, is that that wouldn't mean to say that our internal arrangements would be any the less robust. But just on the point.
Thank you, Mr. Mosley.
I covered
colleagues, any other points they wish to pursue and follow up? Well, thank you. One final point for Mr. McGregor. When the new National Crime Agency is set up, does UKBA become part of it, or a part of UKBA link in with it on pursuing?
No, the agency will remain a separate agency. We will form part of the... we're part of the Organised Crime Partnership Board with the police, with SOCA and HMRC. So we're very closely linked into the National Crime Agency, and there will be a Board of Policing Command aspect to the National Crime Agency, but the UK Border Agency will remain a separate organisation.
That's helpful. You've clarified what I think I was imagining was going to happen. Thank you very much. I'm sorry we're running slightly late. Excellent evidence session again. Very grateful to the information you've given us. Could I ask then all non-committee members and members of the public, please leave the room quite quickly. We wish a few minutes private discussion.
Committee Room 6, sound.